matter of Charles J. Cradaville versus Mark Angelson, Gregory Brown, Susan McHugh, Joseph Rigby, and Sandy Stewart, with Rutgers, the State University, as intervener. If I could have the appearances, please.
Good morning, Your Honor. May it please the Court. Flavio Cubas, KOMBES of Weissman and Mintz, for the plaintiff, Mr. Cradaville.
And for Rutgers.
Good morning, Your Honor. May it please the Court. Peter Venero from Sills, Cummis, and Crows, appearing on behalf of Rutgers and the individual defendants.
Michael Carucci from Sills, Cummis, and Crows, appearing on behalf of defendants and Rutgers.
Okay. This is plaintiff's challenge to the Rutgers Board of Governors, individuals who live out of New Jersey, based on the New Jersey First Act. So we'll hear first from plaintiff's counsel.
Your Honor, this matter is before the Court on cross motions for summary judgment, initially filed by the defense, responded to by Mr. Cradaville. In these summary judgment papers, the plaintiff has made out a prima facie case that the defendants are, in the words of the New Jersey First Act, subsection D, illegally holding or attempting to hold an office in violation of the New Jersey First Act. A violation of the New Jersey First Act exists under two circumstances. One, where a non-grandfathered holder of an office, position, or employment is out of state when they're appointed to office, and they fail to move in state within 1 year without obtaining an exemption from the NJFA committee. The second circumstance in which there's a violation, and although it's not before the Court today, it's relevant to the statute of limitations issue, is when the holder of a non-grandfathered office who lives in state subsequently moves out of state without obtaining from the NJFA exemption committee. And the local finance notice, which was in our papers, explains both of these circumstances. The local finance notice that I mentioned before stands for the proposition that the New Jersey First Act, first of all, that they have the authority to interpret the New Jersey First Act. Second, they are interpreting it on behalf of all levels of government. And three, that volunteers are subject to the New Jersey First Act. In response to the prima facie case, Rutgers has basically asserted three defenses. One, the New Jersey First Act does not apply to volunteer members of a board, of a state instrumentality or county instrumentality or local instrumentality. And second, that the New Jersey First Act, although applicable to Rutgers employees, and we know that Rutgers concedes it applies to their employees, cannot be validly applied to those who hold office on the Rutgers Board of Governors. And then third, they have a statute of limitations defense. With regard to the applicability of New Jersey First Act, I think we've put out in our papers pretty thoroughly that under the text and history and structure of the statute, it talks about every person, very interpreted to mean very expansive application. Every person in the state government, state boards, state instrumentalities, state institutions of higher education.
What do you make, though, of the fact that there was no reference in the legislative history to expanding it to volunteer positions? And one of the things I'm interested in is that when you look at the history of these residency statutes or ordinances, and the case law in New Jersey, Kennedy case, Abramson, I think it is, it was always in the context of employment because of the economic conditions of the time often seem to prompt these kinds of statutes. We want our employees to be within the city, within the state, so that their salaries are used in the state, and unemployment is addressed to the extent of public employment going to residents. And that's the history of this kind of statute. I mean, the broader context, not the specific one here. So how does it have, do you make anything of that?
Well, I think it was, quite simply, it was expanded in 2011, and very broadly so. In 1987, it talked about office, and it defined office in a very particular way. It was governor, cabinet member, judges. I think that was it. And then in 2011, it's expanded to talk about not just employment, full-time employment or part-time employment, but they also talk about office. They talk about positions. And then as you read through the different subsections of the statute, there are just countless examples where, given the statutory language, state boards, state commissions, state instrumentality, counties, locals, that falling within the scope of the New Jersey First Act are people that are known to be volunteers, state college trustees, county college trustees, local members of the Board of Ed, by state agencies. And in subsection A2, there's this reference to, basically it says, with regard to the by-state agencies, subject to law, the New Jersey First Act is being made applicable to the by-state agencies. Now, the explanation for that is that the by-state agencies include typically commissioners from more than one state, from two states. So the legislature is not trying to impose the New Jersey First Act requirements on commissioners of the Port Authority, the Delaware River Bridge Authority, things like that, who come from Pennsylvania. But with regard to the volunteers, and the statutes are clear, these are volunteers who are from New Jersey, the statute brings them in. And the statute brings them in on state boards and county boards and local boards in their definition and in the expansion in 2011, both of the categories and by saying, instead of office, employment, or position. If it turned on the question of compensation, that only compensable employees, office holders, or position holders are subject to the Act, then I think we would have expected something in there that said it's limited in this regard.
I mean, having been lawyers, we see, particularly in contracts, where synonyms are used, and it's a frequent thing. And so, how can you be sure what it means in this context? Because perhaps you could have office holders who are both, paid and unpaid. The defendants point out different. Parole board, for example, they're paid. And so, how do we know what the legislature intended by the use of these terms in this statute? When there was, it just is strange to me that the breadth that is the basis of your argument, which was not at all mentioned in any of the legislative history that I can, that anybody's brought to my attention.
No, certainly, I mean, the word volunteer wasn't mentioned. I'm not going to say that it was, but in the examples of who they were subjecting to this law, there's just so many examples of volunteers, volunteer boards. There are many examples of paid. I get that. There are also many examples of volunteers. And I take your point about synonyms, but you have to give effect to every word in the statute to the extent that's possible. An employee has a particular meaning, whether it be full-time or part-time. Office has a particular meaning. Position has a particular meaning. In the litigation over BOG member Martin Perez, the court there is another, it was a quo warranto action. They talked about him holding office.
And then the purpose of the statute. In your argument, you've come up with a purpose that individuals involved in significant administrative roles, even such as the Board of Governors, it's important to have them live in the state of New Jersey. But that purpose was nowhere articulated by the legislature, was it? And not just as to Board of Governors, but, what any other board for state colleges, other state universities.
Right. The objective is not stated in the legislation. I know the defense is going to talk to you about the signing statement or the veto statement from Governor Christie. But again, you come back to it just makes common sense that when you have individuals such as these board members, in their term, they are controlling $16 billion with a B dollars of income and expenses that are going through Rutgers. And this includes money from the Treasury. It includes money from students who live here. It includes money from patients who seek health care at the Rutgers health systems. To not have somebody involved in that who is steeped in New Jersey, who resides here, it's not really a logical approach when you look at all of the other high-level policy-making positions in New Jersey. Many can control budgets far less than that. Different cabinet agencies.
But this is you. This is your argument. This is not what the I mean, it's the whole point of this exercise is to determine the legislative intent. And it's when the legislature doesn't say anything on the particular subject matter, and the language is such that they're having different meanings proposed by each side, and there is the breadth that you're saying was a major revision, and the thrust of the major revision was to encompass all public employees, including our judiciary employees.
Yes.
It just is sort of, I'm uncomfortable with the silence and what that means, and with the purpose, I mean, we have to get into the purpose if I have to decide the contract clause issue. But not to have the legislature say the purpose is a little bit is concerning to me.
I understand. I mean, what I can point to you is the fact that even as employees, it was a huge expansion from 1987. And, if Your Honor is not persuaded by the statutory text, then I would turn next to the local finance notice that I alluded to before. And this is in the immediate wake of the passage of the law and the Division of Local Government Services, whose finance bulletins have been deferred to by the Supreme Court in the past as agency action, expressly says it covers volunteers. We are, this is again, it's this major expansion, and in their estimation, that local finance notice, as far as I know, has never been challenged in court, successfully or otherwise, in the 7 years that it's been in effect. And it says volunteers are covered.
So what do I do with the agency, with an agency that is giving advice, and then, the fact that the governor appointed, within not much more than a year after New Jersey first, appointed individuals who were living outside the state, but it seemed as if there was no understanding they'd move into the state in light of their positions, and that those were confirmed by senators who voted for the bill and the governor who signed the bill. And the statement that you mentioned your adversaries have raised, where the governor was it a conditional veto,
yes,
and mentioned that it was public employment. So I grant you, local government services did say it applied to volunteers, but then there are these, the actions of legislators themselves and the governor. So I mean, I have things on both sides.
Yeah, I mean, the thing is, the governor and the legislature. There's nothing illegal. Governor Murphy appointed 3 out-of-state folks to cabinet positions. There's nothing illegal in appointing somebody from out of state.
But I mean, the common sense, approach. I mean, not the common sense, but these individuals are major corporate figures, and as opposed to offering them paid employment to come into New Jersey and take a cabinet position, they're asked to volunteer on the Board of Governors that meets approximately 6 times a year.
6 times a year.
And so, and then there was it Mr. Brown, who was actually, after the first 6 years, was reappointed to a second term. And he had lived outside the state for the entire 6 years, and I believe that was, was approved by the Senate. So, I mean, if I'm looking for legislative intent, there's a rule that says you look at an agency, and an agency that's interpreting and applying a statute, you can give that some deference. On the other hand, I have statements of the governor who supported the bill, and actions by some key, the Senate anyway, and in confirming confirming one of the appointments.
Yeah, I mean, one of the things missing in that is obviously the Assembly. And this is a bicamerally passed and presented bill, and it became law. And, there could be an inference drawn. That's what the defendants would ask you to say, that the governor appointed this person. There's other explanations to that. There's explanations that they either hope they would move into state. I don't know.
But that seems silly to me, frankly. It seems silly in the context of a major university getting corporate, major corporate officials, who are based in other places. I mean, the cabinet example is very different. It's employment. You're coming here. We're giving you a salary. So, it's just a difficult problem with having different arms of the government giving different indications of what they think how the statute should be employed in this particular case.
Well, I mean, that is how they employed it, but, an explanation is they were in violation of the law. They appoint someone who they know is not going to move in, a paid employee. There's no intention to grandfather them. There's no intention to exempt them. They could be breaking the law. They could be hoping that circumstances change. They could be hoping they're not called out. I just think that the simple act of appointing somebody in what is, at the moment, an entirely legal appointment, when you are in the face of the statutory text, in the face of this agency guidance, missing one house of the legislature that passed the bill.
Missing one house. I don't, that to me seems a bit extreme to say. I mean, it's the truth. We don't know what the Assembly thought, but in legislative history, you can cite a statement from the Senate, you can cite a statement from the Assembly. So, I mean, that has, no sway. And under the statute, who is the body that is the one that looks at on the Board of Governors? It's advice and consent of the Senate.
The Senate, sure.
And so who would you expect to be the most appropriate to comment on it? It would seem to me it would be the Senate. Although we also have I don't recall, but maybe you do, the Board of Governors member that's recommended by the Senator, by the Senate President and the Assembly Speaker. Is that a New Jersey resident, or was it one of the four? Do you recall?
So the defendants in this case are three public governors who are appointed by the governor through advice and consent of the Senate, and one trustee governor who's appointed by the trustees. Right. The two individuals that you're speaking of do have state and, in fact, county residency requirements.
Oh, so that was the 2012.
Right, so that was Mr. Perez, for example.
And in terms of the 2012 statute, when the legislature wanted to have a residency requirement for the Board of Governors, they did it explicitly in the 2012 amendment to the Rutgers Act, with the requirements of that one has to be from Camden and one from Middlesex and one from Essex. So if we see that they were keyed into residence requirements in 2012, should I make anything of that? That it was the New Jersey First Act didn't say anything about that, and when you're looking at specific statutes versus general statutes, is that anything I can glean in terms of legislative intent, or should glean?
So the 2011, the applicability to Rutgers, leaving aside the volunteer question for a minute, the applicability to Rutgers there in the New Jersey First Act was very clear. And I don't think that you could say the 2012 Act somehow impliedly repealed the requirements of Rutgers. there were the residency requirements established by the New Jersey First Act. They were already there, and
well, they were explicitly applied to the faculty because they had an exemption. There was a particular exemption. That section under A, where Rutgers has to give a report. So a report on who they want to exempt. So I agree with you that the New Jersey First Act did apply to Rutgers. It's just whether the language that was used extends to the volunteer members of the Board of Governors.
Right. So the New Jersey First Act, I mean, says it's actually not even within the exemptions, but in B2, every person holding an office, employment, or position with an authority, board, body, agency, commission, or instrumentality of the state, including any state college, university, or other higher educational institution. So that Rutgers was brought within that under A2 is clear on a number of different levels. In terms of affecting the members of the board, and this comes back to office and position. They hold that Rutgers it's a board. It's a board of a state higher educational institution and a board of a state university. That's what the legislature did in the New Jersey First Act. Was it necessary for them to refine that? Look, the 2012 Act certainly didn't have any provisions in there about it applying to employees, because it already did. And in the 2012 Act, there was not any amendments there were amendments to the Board of Governors statute because they added the county residencies. But with regard to the application of the board, I'd submit that was already settled in 2011. And just because the governor appointed somebody and the Senate confirmed somebody, there's no, in the legislative history, there's certainly no indication about exemptions to volunteers. It's just as easy to infer that this is a violation of the law as it is from an intent to say that the law never applied. It's not found. This specific reference to Rutgers governors is not found, but there is a specific reference to Rutgers. There is a specific reference to office holders at a state instrumentality, including a state university or institution of higher education. This was all already there, and I just think if the state wanted to limit it to employment, to paid positions, they could have said full or part-time employment. They didn't say that. They said office, employment, or position. And the state agency that interpreted this said, yes, it does apply to volunteers. And the exemption committee, which I'm sure you're going to hear about from the defense, the exemption committee expressly disclaims their ability to rule on the applicability of the law. They rule on exemptions.
And their form has, assumes that it's by an employee because the exemption is connected to hardship, and hardship is typically viewed in economic terms, and the Board of Governors are not compensated, so it seems as if that exemption really, they didn't, that board, that committee didn't envision it applying to unpaid individuals, apparently.
Well, except that that is certainly what their job is, to rule on exemptions proposed or requested by employees. That's been the focus of their action. If you go on their website, you'll see hundreds of requests every year. I haven't looked at every one, but certainly the focus is employment. But I'm not even talking so much about the what they're deciding in employment cases. I'm simply saying that on their very own website, they say we do not have the That's not our function to interpret the Act. The LGS, on the other hand, says it is our function to interpret the Act, and we say it applies to volunteers.
When you review the statute, do you think that the Board of Governors who live outside the state could apply for an exemption?
They could.
Yeah, I know that they have chosen not to.
They've chosen not to, and they would. The defense will tell you that that's improper to ask them to go through this process that every other, office holder, position holder, employee who wants to live out of state and serve the state has to go through. I'll get into.
Would that satisfy plaintiff?
If they apply, they have the right to apply. I mean.
And if they got the exemption, that would be one way to cure this.
If the exemption were granted and was not challenged, or was challenged and was upheld.
Is there any basis to challenge an exemption? I mean, does that come into the authorization under the statute? I mean, I don't know.
No, the statute doesn't speak to any right of appeal. I've looked through. I mean, you look at any given month, and you look at the dispositions, and there's some grants and there's some denials. Probably most are grants. In terms of somebody who's denied, whether they have the right to seek judicial review of that and where that would be, whether it be this court or the appellate division, I haven't found anything. I have not.
Well, that's an individual who could appeal their decision in their own case, but this is the private citizen right to the right that they're given under the statute to oust.
Right.
Do they also have a right to challenge it? But this is all speculative, so we're sort of getting a feel of where we need to be.
Right. So I would just say, I mean, the breadth of it, when you focus on every person, when you look at the enumeration of a board of a higher education institution or state university, when you look at the DLGS interpretation of volunteers, I think for all those reasons, the statute does apply to them. And as a policy matter, I want to, again, emphasize $16 billion over their term. That's what a Board of Governors member controls. That's not even private parts of the Rutgers budget. That's state tuition, grants from the state treasury, fringe benefit aid, and health care revenue. And
at the moment, the majority of the Board of Governors are New Jersey residents, and some of them in the counties that are required by the amendment. So you certainly have a majority. Does that make a difference? I mean, we have a majority of New Jersey residents. Doesn't that satisfy your concern?
Your Honor, the statute in our reading requires every member of a collective body, every employee, every low-level employee.
No, I know that, but you were making a policy argument about how it should be New Jersey residents who make these important decisions with this money, and certainly the majority of the board are New Jersey residents. So I just was questioning the weight of the argument.
Sure.
You just made.
No, it's a fair point. I had mentioned we had mentioned that as a counterexample, as a somewhat of a thought experiment in response to that. New Jersey does business with countries around the world. And I'm saying New Jersey companies do business with companies around the world. We have tourism. It does not follow that just because we have international relationships that the legislature, the Senate, the cabinet, and the judiciary should be open to people from other states. No more than the Rutgers Board of Governors. The entirety of the board should be open to people from other states when this is the one state in the union where Rutgers has facilities. The only out-of-state facility that we are aware of is the lobbying office in D.C. They have exchange programs. Sure, they have exchange faculty, research programs, but no facilities outside of New Jersey. And we know what the size of the Rutgers budget is. And these are high-level apex policymakers, and all of them should be immersed in New Jersey and be responsible for the consequences of their decisions in New Jersey. That's what
this was something that the legislature really didn't focus on, because sometimes you see that, and in legislation that the main thrust of it, I think, was to expand to all public employees. And yes, they applied it to boards, agencies, including state universities. But but your position is if the change is if it is not to be applied to the Board of Governors, it has to be a legislative fix.
Yes.
It should not be a judicial, adding on adding language that's not there, and so forth.
Absolutely. And look, if Rutgers, well, I should say if the Board of Trustees of Rutgers, we'll debate that one momentarily, I suppose. But if anyone wants to go to the Board of Governors and say, look, I think, there are bills to repeal the New Jersey First Act in its entirety, pending right now. But if somebody wants to either support that or seek out an exemption for Rutgers, that's where they should go. I agree with you. The main thrust of the New Jersey First Act was to cover employees. But it's not the only one. And that's why you have terms like office, position, employment. That's why you have the LGS's interpretation covering volunteers, contemporaneous with its passage.
And if I were to agree with you that the plain language of the statute requires that the Board of Governors, any member, live in New Jersey, is it necessary for an immediate ouster? I mean, when there has been, when at least I have some contrary evidence of the local government memo or whatever it was that says applies to volunteers, and then we know what the governor and the Senate have done. And so there certainly has been uncertainty to the extent that Rutgers is saying, even though we think this is untimely, you should decide the case. So because we need certainty. So is this an immediate ouster in light of the sort of the history of how this has played out since 2011?
So certainly I think the court has the authority to do that, but I think the case law is replete with instances where, and I was thinking of Forrester v. Palmer, which dealt with the police chief in Trenton, where he was granted a certain extension, the city was granted a certain extension of time to identify a replacement. So if the court is not comfortable with ousting the 4 members of the board immediately, I think the court has within its authority the power to grant some amount of time where they could be replaced. Not asking you to do that, but I certainly recognize that's certainly within your discretion under the case law as it exists.
You can move on to the next point.
Okay. So the second point I think I'll talk about is the issue of the contracts clause. So the defense has raised the contracts clause as a defense. It's obviously their burden. And there are 4 well-settled prongs that the defendants have to meet. They are only alleging the NJFA is unconstitutional as applied to the board. They are not alleging it applies to employees. So the first is that there's a party to the contract that is a litigant before the court. The second is that it's a substantial impairment of the contractual rights, not just a breach, not just an impairment, not just affecting, but a substantial impairment. And then the third and fourth prongs you get into balancing in terms of the legitimacy of the state interest and how that interest was tailored to achieve the stated goals. Before we get into the Commerce Clause at all, I would mention that under the Egerton case, there is a Supreme Court decision from 1978 that says when you are dealing with laws of general application, like the New Jersey First Act is, you can't say that there really is no contracts clause argument available at all. And I gave some examples of laws of general application that maybe impinge or take away from the Board of Governors' powers a little bit. Law against discrimination, prime example. Law against discrimination dates from 1945, but after the Rutgers Charter, different categories were added. Sex, sexual orientation, age, among others. They apply to Rutgers. The OPRA applies to Rutgers. OPMA applies to Rutgers.
But are they of a somewhat different nature, though? I mean, in terms of the application of the statute to the Board of Governors going to the self-governance of an institution. It seemed a little bit different anyway from the anti-discrimination statutes and a number of the other examples he gave.
Well, if the question is, Rutgers certainly has less autonomy than it did in 1956. The trustees have less autonomy for picking the public governors. For the trustee governors. The governor of the state has less freedom than he had in 1956 to pick the public governors by virtue of all these laws. I mean, I mentioned the criminal forfeiture statute, that somebody who's committed an offense and is barred from public service, they can't serve. In the operations of Rutgers, OPMA, OPRA, there's statutes saying you can run your meetings as you see fit. That's in the Rutgers Charter. Nevertheless, we have these laws that affect that you can manage your employees, but we're subject to the employer relations.
Without consent.
Without consent, that's right.
Consent.
That's right. So the New Jersey First Act, it's certainly broadly intended to apply. It is just nothing more than another law of general application for which there's not a contracts clause argument available. If you don't see it that way, they still have to prove those four elements of the contracts clause. With regard to whether there's a party before the court, a party of the contract who's also before the court, the way the Rutgers statute is set up, they've said this repeatedly, they've told the Supreme Court this in Peluso, they've told the general public this on their website. They say there is a contract between the state and the Board of Trustees, and a consequence of that contract, the creation out of that contract is Rutgers University. And if the state doesn't live up to its end of the bargain, changes the name, changes the president, any number of things that the state can do, then the trustees, the way the statute is written is the trustees can take their ball and go home. They can withdraw the trust assets. And we acknowledge that's not going to happen. But
the courts have also noted
correct.
that it's more that they could withhold or
right.
withdraw. What was the language? More theoretical than real.
More theoretical than real. And I agree with that. But if that remedy is not available, then who sets in motion the process of obtaining a decree, of going to court, saying, look, the state is underfunding us. Look, the state changed our president. The answer to that is still the Board of Trustees. They're the party to the contract. That's what the statute says. That's what the courts have said. That's what Rutgers has said. I don't know why they didn't intervene. Rutgers intervened. But this is where we are. So I don't think there is a party somebody who is a party to the contract that is before the court. And I think that's the end of the contracts clause right there. Now we get into substantial impairment. And there's three different subsets of substantial impairment. I want to start first with the trustee governors. So the trustee governors under the 1956 Act, they can appoint from among their number pretty much anyone they want to the board. They can't violate the criminal forfeiture statute. They can't abuse the law against discrimination or the Civil Rights Act in making their choices. They can't appoint someone where it would be a violation of the State Ethics Act. So what are they left with? They are left with 7 million adults in New Jersey, 250,000 alumni, educated populace, highly educated populace with doctoral degrees, a wealthy populace that they can all choose from. And so when you think of this in terms of a substantial impairment of their right, it's not as if their choices are being cabined down to a small number of people by their own criteria: alumni status, academic achievement, wealth. There are just so many individuals that can be approached and can be asked to serve. And if they're from out of state, they can be asked to move to New Jersey. So when you look at the expectations under the 1956 Act, this is not a substantial limitation on it. In fact, in the Rutgers statute itself, in 1865-27,
that's the
Sorry,
public policy of the state section.
Public policy of the state, yes. So this says if the provisions for essential self-government of the university are amended or altered in any substantial respect, or repealed, then that can trigger this, maybe this theoretical withdrawal or the right to go to court.
And it includes the Board of Governors provision.
Oh, yeah. And the Board of Governors provision, and it includes Section 25, which, as I mentioned, the state has, chipped away at over the years by adopting the ethics law, the criminal forfeiture statute, et cetera, without consent. And this is another example of a law of general application, where it's, as to the trustees, it says you can't do that. Now, with regard to the public governors, however, the case is much stronger. Even though I think I've demonstrated there's not a substantial impairment of the trustee governors, the public governors, here's the thing, Your Honor. Ever since the 1965 Act passed, Rutgers had no ability to tell the governor of New Jersey who to pay. They could ask. I could ask. You could ask. Mr. Cradaville could ask. Defense counsel could ask. But there was no right on the part of Rutgers or the Board of Trustees or the Board of Governors that they had a contractually enforceable right to make the governor appoint somebody. Well, this is a contracts clause analysis. You can't impair a right that you never had. And for Rutgers to come in and say, well, we have the ability to ask the governor to appoint somebody from out of state, had no contractual rights, had no judicial review rights of that. They've never had that right with regard to the public governors. So how you can say that's a substantial impairment, I'm not seeing it. The alternative argument is the removal provisions. So the way we read the removal provisions is saying, no, this is one way that a person can be ejected from the board for conduct injurious or for malfeasance. And there's a process in there that it has to be commenced, and the board has to rule on it, it has to go to the appointing authorities, and so on and so forth. That is one way. I allude also to, again, back to the criminal forfeiture statute, is Rutgers taking the position that if somebody commits a crime that falls within the criminal forfeiture statute, no, you can't remove them under the criminal law because the trustees didn't consent to that. I think that position would be absurd, or you can't, if they're voting on matters to promote their self-interest in violation of the State Ethics Act. Now, the State Ethics, where they can't punish them, the trustees never consented. It's one of these things that it's not a sensible approach.
The only thing I've seen in terms of consent that's in the record here is Rutgers provided all of the resolutions consenting to the state statutes that change their governance, or particularly the 2012 change. But it was interesting, in that resolution, I didn't see any comment on the change to the Board of Governors residency requirements, where the change was one had to be from Camden, one from Middlesex. It was the concern seemed to be largely over the medical schools.
Right, and that's what was up at the time. Nor will you see any consent for the LAD expansions, the criminal forfeiture statutes, the Employee-Employer Relations Act. You're not going to see consent to those things that affected how Rutgers was governed.
There was no consent to the New Jersey First Act in a resolution, even though it did address the state universities and faculties and so forth. I mean, I don't know that there was any. I didn't see anything in the record that gave consent to the New Jersey First Act.
No, I'm agreeing with you. There's not an active consent to the New Jersey First Act. My point is that it's not required. Just as it's not required, and you're not going to find in the record anything for these other laws that literally affected who you can choose.
Yeah, but what I was thinking is that Rutgers went along with it, particularly in terms of providing this report, in terms of the faculty members and so forth, without any resolution as to consent, which is, I'm sort of suggesting that, is that something that supports your argument?
I mean, look, certainly no objections were interposed, and that is an acquiescence, as they've gone along with any number of things. So what I'm saying is the argument. So there's another piece of the Contracts Clause premised on Section 19, and the Rutgers Act does not abolish the right of quo warranto. That's why people were able to go after Mr. Perez for his service on the board. The argument could have been made, look, he's been appointed, he's been confirmed, he's a sitting member of the board, he can't be removed except through Section 19. Not even a thought of any of the litigants or the courts in that case. And Section 19, so we're left with Section 19, is Section 19 is one way to remove somebody. And quo warranto is also another way to remove somebody that is not inconsistent with other. There are multiple means of removing somebody from the board. Section 19 is just one of them, and quo warranto is one of them, and that's effectively what this proceeding is. We're asserting these individuals are not residents. They do not have the right to continued possession of the office. They should be ousted, whether it's granted immediately or there's a stay. That'll be up to Your Honor. But there's nothing in Section 19 that substantially impairs, and that is the test for Contracts Clause. There's nothing in Section 19 that substantially impairs the rights of the party, who isn't, by the way, before the court, the Board of Trustees, or for that matter, these individual governors. It's not there. The other two aspects of the Contracts Clause, I've illustrated that it is acknowledged by the U.S. Supreme Court that apex-level policymakers, perhaps even more so than lower-level employees, can be subjected to restrictions. Gregory v. Ashcroft is one case, dealt with retirement ages of judges and the applicability of the ADA. Galley represented a case involving employee-free speech, and to what extent an employee who is or is not a policymaker is allowed to engage in free speech. These are instructive because what the state is doing, which the way I read the New Jersey First Act, is what the state is doing is saying these apex-level policymakers should have the New Jersey connection, and we are, under the Constitution, allowed to have residency restrictions for them. We're also allowed to have residency restrictions for lower-level employees, granted, but especially for people who control massive, massive budgets, massive student bodies, massive workforces, that it should be, the state's power to impose qualifications on people exercising that kind of power is really at its zenith when you're talking about policymakers. So there is a legitimate and there is an important state interest that is furthered here, and the defense has not shown otherwise. And with regard to the last prong of the Contracts Clause, which is the issue of whether it's reasonably tailored to the objective, I think here what we have is a situation where the state said we're going to have grandfathering. Well, first of all, we're going to have grandfathering for anyone before 2011. We're going to have a 1-year grace period. We're going to have an exemption committee. And this was not some sort of onerous imposition that violated that prong of the contracts clause. I do think it's worthwhile. One thing I wanted to mention is the state says, well, there was no emergency. And they cite to the U.S. trust case. And the rest of that footnote, talking about emergency, says, undoubtedly, the existence of an emergency and the limited duration of a relief measure are factors to be assessed in determining the reasonableness of an impairment, but they cannot be regarded as essential in every case. That's U.S. Trust versus New Jersey 431 U.S. 123 footnote 19. So there is no requirement for an emergency. There is a important state interest that the state tackles in a reasonable way. And that's what they've done here with the New Jersey First Act with respect to the Board of Governors. So that's it on my contracts clause.
No, that's fine.
Move on to the statute of limitations. So the statute of limitations here, it's our position that there are two ways in which the court could dispose of the statute of limitations argument. First is that under the text of the New Jersey First Act, when you have an ongoing violation, the way the statute reads,
It's any 365-day period.
Correct, any 365-day period. And when you consider that it is entirely possible that somebody could violate the New Jersey First Act, not just by being appointed as a non-state or not moving in, but also by moving out of state once appointed.
I think in that Kennedy case, which I don't know that was cited here, but when I was looking at the residency cases, there was somebody who took a job in Newark and, moved out, moved in, trying to reconcile with husband, moved out, and so it certainly is a fact pattern that has come up in other applications of a residency requirement.
Right. So the question really is, we don't have people who were residents and moved out, but the point is the statute of limitations can begin to run at a time other than appointment. And it is our contention that when you have an ongoing violation, for the defense to come in and say, look, I should not be held to account because I've been violating the law for 5 or 6 years. I continue to violate the law. Rutgers even suggests there may be future instances where this happens. The statute of limitations does not begin to run. The complaint was drafted in such a way as it says, we allege there's a 365-day period. For 1 year prior to the filing of this complaint, these defendants lived out of state while serving on the board. To be sure, they were out of state for longer than that. We acknowledge that. Their service began when it began. But in the face of the ongoing violation and the doctrines that apply to this concept, just under statute of limitations purposes, they can't prevail just because the violation is ongoing. The alternative argument, I think, the defendants had embraced this concept that you shouldn't look to the 1 year statute of limitations, but you should look to the prerogative writ statute of limitations in 469-6. Well, if you do that, you also have to look at 469-6C, which is the exceptions. The Mullen case, Mullen versus Ippolito, which I discussed at some length, this is an instance where these neighbors of a oceanfront motel, for years and years, the town had let their snack bar expand, had let their structures expand, had let their impervious coverage expand. They were letting people hold weddings and do exercise classes on the protective dunes in violation of the local dune ordinance. And this happened over many years. And eventually they sued. And in response to the allegation that this was time barred, the court says cases involving important and novel constitutional questions, 2, informal or ex parte determinations of legal questions by administrative officials, and 3, important public rather than private interests which require adjudication and clarification to satisfy the interest of justice, exception to 469-6. That's Mullen versus Apollo 428, NJ Super 85, 106, after 2012. And I think that, and this is, I mean, you talk about people sleeping on their rights. I mean, anytime there's a request to invoke 469-6, it involves some delay on the part of the plaintiff. But I think Mullen presents is an instance where the court decided this is something that should be decided. Rutgers itself says this is an important case. This is a constitutional case. They're sort of, I think, in a sense, admitting to the requirements that the court directs us to fulfill in looking at an interest of justice exception. Its importance, and its public character. So to the extent that that's the governing law, 469-6C, the interest of justice exception here has been satisfied, and that would be an alternative grounds on which to find the statute, find the case timely. One thing I would add also is that Rutgers argues that if the court chooses to dismiss the case on statute of limitations grounds, that the court should nevertheless proceed in violation of the constitutional avoidance doctrine to rule in the contracts clause issues raised. And I think that would be a mistake. The doctrine of ruling on the merits when a case has otherwise been thrown out for other grounds, it's typically mootness, and it's typically the concept of capable of repetition while evading review. And what I would suggest here is that if Mr. Cradaville's action is time barred, and if Rutgers chooses to appoint another out-of-state person, there will be ample time. It's not going to evade review. There'll be ample time to litigate that, and I don't think the court should give Rutgers a free advisory opinion, especially on a constitutional question, when those criteria haven't been satisfied. I think we satisfy the statute of limitations. I'm just sort of, throwing that out there if the court disagrees with that concept. At the end of the day, Judge, the New Jersey First Act affects a broad swath of public employees. If it affects the employees, it should certainly affect the policymakers as well. And when you see the legislature writing this kind of broad language about who it is to impact, and it's sensible, it is sensible that it should impact high-level policymakers that have billions of dollars of budget under their control every year, that the appropriate course of action is to remove these individuals from the board.
Thank you. There was one thing I did not ask you. Had you looked at all a case called Solly v. Woodbine Board of Education, SAHLI? It's 193 NJ 309.
I did not, Your Honor.
Okay. Well, maybe something to think about. It came up in a very different context, but it's a Supreme Court decision where the court looked at the exact same words, office, position, or employment, in the context of an indemnification clause. Very strange, well, I don't know if it's that strange, facts. It was a Board of Education attorney was involved in a case, there was an issue before the Board of Education, and there was concern that the board secretary might have, I don't know if it was a conflict of interest, but when the board went into executive session to address the issue, the board attorney substituted in for the secretary and took all the notes. And subsequently, the action that the board took regarding the employee that was the subject of the note-taking led to her filing litigation against the board. And it came out in discovery that it wasn't the board secretary who took the notes, it was the attorney sitting in. And he's not paid as the official board secretary, but the Supreme Court applied it to volunteers, the exact same language, but it's a different context. And I was just curious if you had seen it, and it hasn't been cited, but it's there's in the partial dissent and concurring by Justice Albin, he goes back to a case in what was it, 1912, that gave a definition of position being analogous to office, but they applied that language to volunteers.
Yeah, and in our opening brief, we did discuss, we did cite some case law about position and office involving volunteer board members. And there's other cases out there about, the SPCA, and there's cases that arise under the criminal forfeiture statute that has analogous language of position, office, or employment. But I thank you for pointing that
well, I was curious
case
about
out,
it,
but I
so
did not see it.
maybe you want to look at it and the other defendants as well. 193 NJ 309 from 2008. Very different context, but getting into what do these terms apply to someone who's a volunteer? Although it was an unusual scenario, that the majority held that the attorney was not covered by the indemnification. He was an independent contractor, and that's where Justice Albin disagreed and said he should be covered even as an attorney, because the majority said that when it was remanded, they had to decide what part of his actions were covered as the secretary and what part were not covered as the attorney.
Thank you.
Okay, thank you. We'll hear from the defendants on behalf of Rutgers.
Thank you, Your Honor. May it please the Court. The one overriding fact that I believe really greatly informs the legal analysis in this case is that Rutgers is a unique institution. It has a unique legacy. It has a unique history. It is not a department or division of state government. It predates the state of New Jersey, is distinct from the state, and was not established by the state. Rutgers is an autonomous institution as recognized under the codified contract with the state itself, a contract that the Supreme Court in New Jersey has said and referred to as a consummated contract. That's really the overarching fact that I believe informs the analysis on why we think this case should be dismissed for any one of three reasons. Under plaintiff's interpretation, the New Jersey First Act violates the contract clauses of our federal and state constitutions. And I'll get to those in a moment, Your Honor, the various factors. Secondly, the New Jersey First Act was never intended by its drafters to apply to volunteer board members, such as members of the Rutgers Board of Governors. And I have quite a different view of the legislative history on that than my colleague does. And thirdly, even if the statute does apply, plaintiff's suit is untimely. It's untimely either under the statute of limitations contained in the New Jersey First Act, or it is untimely under the court rule. If I may, Your Honor, I'd like to briefly touch on the factors for the contract impairment analysis. And I'd actually like to start with the analysis of the conduct of the state, the three, what some of the case law calls the three factors that run to the conduct of the state. And the first question there is, does the New Jersey First Act lack a significant and legitimate purpose sufficient to impair the contract? And I think, Your Honor, really opened up a nice discussion on this with my colleague. And the answer, we believe, there's only one answer, and that is yes, it does lack that purpose. And the reason is the only stated purpose of the NJFA, the only purpose stated in any of the legislative history, is to ensure that New Jerseyans occupy positions of public employment. In essence, this was a bill to aid New Jerseyans to secure government-paid positions.
And I mean, the timing was right after the recession, and New Jersey was so slow to recover from the recession. So 2011, it seemed to be related to that very much of its time.
You can make that context, absolutely. And the reason we made such a point of quoting the governor's recommendation is that, unlike most statutes, as Your Honor is aware, where the governor will simply sign or veto a bill, here he conditionally vetoed it through recommendations. And his recommendations then went over to the legislature, and they were voted up in their entirety. So his language in the conditional veto, that veto message, that is atypical in terms of a governor. It's not merely a signing statement. It's part of the bill. His recommendations became part of the bill and is embedded in the legislative history.
I just want to note it's in your appendix.
It is
at Appendix J, and in the statement of the governor, he calls it the legislation would require that public employees obtain a principal residence in New Jersey within 1 year of beginning their public service. He says, I commend the sponsors for their efforts to increase employment opportunities for New Jersey residents by ensuring that citizens throughout the state enjoy access to public positions in their communities. But is there anything in the text of the statute that supports that limitation?
We believe so, Your Honor. If you look at the titles of the various sections as the bills were moving through the legislature, and even if you go back to the earlier time, this statute was about economics. It was about assuring New Jerseyans having access to these positions. And when you measure that against the impairment of the Rutgers Board and its relationship to unpaid all-volunteer board members, the purpose is a non sequitur. It's not only that it lacks a sufficient purpose, there's really no purpose at all to the New Jersey First Act when viewed within the perspective of applying to an unpaid board member. So I don't know how that factor alone can be surmounted in terms of the constitutional analysis. I appreciate the plaintiff has proffered some other type of purpose of fiscal oversight over state entities. But again, and I think Your Honor was asking on this, that is nowhere in the history of the governor's CV. It's nowhere in the history of the bill. It's in no bill statement that I've been able to find. And again, it doesn't even make sense in this sense that there's no suggestion in this record that any of the governors, particularly the out-of-state governors and particularly the chairman who is out of state, there's absolutely no suggestion in this record that they have been poor stewards of Rutgers' finances. It's just the opposite.
Well, the other thing is the argument is that it applies to all boards. And so at least in terms of all boards, there's certainly advisory boards that have no financial impact. They can advise on policy. So the purpose that the plaintiffs are saying is sort of narrowly focused on Rutgers and that type of board, but it doesn't carry over necessarily.
It doesn't carry over, and it's very curious because you're correct, they do focus on Rutgers, and yet, and I think Your Honor pointed this out, nowhere in any of these bills, even going back to 87, which I'll get to in a moment, is there any thought or discussion of Rutgers specifically on the minds of legislators?
Well, then, are you asking me, though, to give a Rutgers exception or to say all volunteers?
Well, this is part of our contract impairment argument. We're saying that there is a contract, a compact. We're saying it is substantially been impaired, and I can get to that in a moment. We certainly believe Rutgers, as the corporation, has standing, and I'm representing Rutgers as the university and the corporation. We certainly have standing to raise the impairment clause, and that's outlined in our brief.
No, but why don't you focus on the contract clause? I got us off.
Yeah, no, that's fine. So if I may, we believe very strongly there is a contract in this case, and I don't think plaintiff seriously disagrees with that. He has other issues, whether we have standing, whether the contract has been impaired. But I believe it's an undisputed fact that there is a consummated contract between Rutgers and the state of New Jersey. It's embodied in the 1956 Act. It has been amended at certain periods of time, all with the consent of Rutgers. And, Your Honor, to your point that the resolutions dealing with the 2012 Restructuring Act, although Your Honor is correct, there is no specific mention of residency. There are in both resolutions very clear language indicating that the consent is required whenever there are changes to the organizational structure of Rutgers. That's on page 3 of the Board of Governors resolution. And on page 1 of the Board of Trustees, there is similar language saying that because the Restructuring Act will result in changes in the organization, management, and administration of Rutgers, it can be implemented only with the consent of Rutgers. So our position is that because they were adding residency requirements for the first time, as well as other things for sure, but because of those management and organizational structural changes, which is specifically referenced in both the trustees and the governor's resolution, you needed the consent of both, and that was had in New Jersey, got that consent in 2012. So we feel there is a contract, it's consummated, the Supreme Court has said it's consummated. We believe that this impairment would be substantial, is substantial, because it strikes at the heart of who may serve on the board of the top and second, the two top governing agencies or bodies of Rutgers, the Board of Governors and as well the trustees. New Jersey has a policy that is well delineated from the 56 Act into the 2012 Act, where the goal for Rutgers is to foster a national and international institution. And to do that, you need leadership that can appeal to stakeholders at a wide breadth. This is not just a question of, well, we have several million people in New Jersey that can serve. That's not the question. The question is, how do we foster Rutgers into the top tier of national and global institutions? And for that, you need to draw from a national and indeed international talent pool. And that's what has been done with these appointments. That's why you can have the chairman of Motorola, obviously fit to serve as on the Rutgers board, obviously fit to manage the fiscal affairs of Rutgers. He lives in Illinois. His company is headquartered in Chicago. Did the drafters of the New Jersey First Act believe for a moment that this volunteer board member, in order to give of his time and expertise and all the tremendous talents that he brings, that he would move his family to New Jersey? We love our state, but not everyone wishes to live here. In order to volunteer at 6 meetings a year, there's nothing in the history of the Act that would suggest that, because the purpose was about New Jersey jobs, not about volunteers. So this idea that this is just incidental to Rutgers, it is more than incidental. When you think of the fact that we have alumni at Rutgers who live in all 50 states, the District of Columbia, 6 U.S. territories, and 6 continents, and you measure that against language that's stated again and again in the 2012 Restructuring Act, that we want to take this university to the next level, a national, international level, that only can happen when you have leaders who can appeal to a wide breadth of stakeholders.
But what about, is the wisdom of the policy anything that I need to be particularly concerned about? I mean, the problem, is with the language of the statute, which says every person holding an office, employment, or position with an authority, board, body, agency, commission, including any state, college, university, or other higher educational institution. So clearly applies to Rutgers, and certainly, board, we have the Board of Governors, and so I think you're really thrown back. We're sort of getting off the Commerce Clause and back into the meaning of the legislation, but it's hard to get away from it because the language, it appears that the plain language supports the prima facie case of the plaintiff.
I'm happy to go into the statutory analysis, just if I may just finish up this.
Yeah, I know, we just keep on getting caught up in it.
Whatever
the
the
things
courts.
you're saying make me
Sure. Well,
around.
let's talk about the statute, and I'll get myself back to the Commerce Clause. The phrase in the statute, office, employment, and position, that's the key phrase. I take exception to what my colleague has said in his brief, and I thought I heard him repeat it today, that the word position was added to the statute as part of the New Jersey First Act. I may have heard that incorrectly, but that's what I heard. That is not the legislative history. Position was added to the statute in 1987, and you can find this in the Carucci certification at Exhibit D. And when you look at the placement of the word position in that series, officer or position, and even when you add the word employment, which did come into effect in the New Jersey First Act, you see the series, office, employment, and position. And whenever you're looking at a series, of course, Your Honor, you look at the series as a whole, and the individual meanings take on meaning depending on the series. We think when you look at that series, particularly when you look at the fact that position was added in 1987 as simply another way to refer to office or officer, then the entire series, to me, suggests that those are all paid positions. There is another part of the history that you can take judicial notice of because the legislative manual is a semi-official publication, I would say, of New Jersey. And that is in between the passage of the 1987 version of the statute where the word position was added for the first time, in between 1987 and 2011 when the New Jersey First Act appeared, there were actually 2 members of the Rutgers Board of Governors who lived out of state. And you could find that in the 1996 legislative manual and the 1994 legislative manual. I believe the court can take judicial notice of that.
And did you cite that in the brief?
No,
okay,
I did not.
So it's the 1996?
1996 legislative manual and the 1994 legislative manual.
Okay.
You have 2 members of the Board of Governors who lived, according to the manual, their residencies were listed as Pennsylvania. And this was after the legislature had added the word position in 1987. My point being, even then, even in 1987, the drafters did not seem to have volunteers in mind with this series or this phrase. My colleague spoke a lot about the Perez case. Perez was not about the New Jersey First Act. Perez was about whether the appointee in that case was appropriately confirmed by advising consent of the Senate, a process, by the way, that was added to the law as a result of the 2012 Restructuring Act, which Rutgers consented to. So Perez actually, I think, is a helpful case for us because it highlights that whenever there is anything dealing with board members, eligibility, confirmations, things that run toward the qualification of a board member, the state has always consistently, since 1945, 1956, 2012, consistently has sought and got the consent of Rutgers, except with the New Jersey First Act. So we think that the phrase officer, employee, and position, they could be used interchangeably, and they speak to paid workers, paid employees.
Had you looked at that Solly case that I mentioned?
I did not,
Okay.
but
I may ask you both to give me a letter afterwards.
Sure. I would be glad to do that. My instant reaction would be that we would hesitate to take too much guidance from a case that was not really addressing a residency requirement under the New Jersey First Act that, in our view, impairs a Rutgers contract. So it is a very different context. And I think you probably could find different meanings of the same word in different statutes. But the key here, of course, is what did the legislature mean when it passed the New Jersey First Act? And we think the governor's conditional veto message is really the definitive guide on what the legislature meant. And it meant preserving jobs for New Jerseyans. We heard a lot this morning about this local finance board agency advice. I disagree with my colleague. That is not the agency tasked to interpret the New Jersey First Act. The agency that is statutorily tasked with the New Jersey First Act is the committee that's embodied in the Act that is housed in the Department of Labor. That's the only agency designated by law to give any sort of interpretive reading to this statute. And they've already spoken. They've spoken in the manner in which they designed their exemption process. And it's designed exclusively for employees. We say that's because volunteers were nowhere intended by the drafters in this statute. And it's also very clear by virtue of the fact that when you see that phrase, and I come back to the phrase, officer, employee, and position, when you see that phrase in the outset of the New Jersey First Act, it's immediately followed by several provisions dealing with employees. Exemptions, those who can get an exemption, those folks who are not exempt, like cabinet officers or judges or justices, which of course are all paid employees. My colleague makes reference to the fact that bi-state entities are covered by this so long as it's consistent with law. Well, we interpret consistent with law to mean consistent with the bi-state compact that governs those relationships. And so too here, Rutgers has a compact with the state of New Jersey. So I don't think that example supports plaintiff at all. If anything, I think it supports our reading that if there is an intervening compact, as there is in this case, then the statute cannot apply to volunteers.
Should I take anything from the 2012 restructuring that gave some residential requirements, and so that the legislature knew how to do it explicitly? Is there anything I should glean from that when looking at New Jersey First, and then looking at when they specifically looked at the Board of Governors in that restructuring act?
Yes, you can take interpretive history from that, because when the legislature knew it and wanted to deal with Rutgers, when they knew that it would be intruding upon or altering the self-governance of Rutgers, they knew they had to negotiate and have Rutgers participation and consent. And residency was part of that. And so the balance was struck. 4 seats encumbered by residency, and the remaining seats are unencumbered. So to go now from 14, or as plaintiff would have this court do, make it all 15 members across the board, would be more than just a slight change. That is substantial. And it also is contrary to the other policy pronouncements in the 2012 Act that I have recited here this morning about how we want Rutgers to reach high. We want Rutgers to be on an international and national playing field. We want Rutgers to compete with top-tier universities. That can't happen when you're going to employ a parochial jobs bill, basically, to Rutgers. It's simply inconsistent, and it would hamper and stunt the growth of the organization in a very significant way. Precisely the sort of thing that the contract clause prevents, but also it's reason enough why Your Honor can look at the plain language of the statute and say there's no mention of volunteers. The legislature knew how to encumber eligibility requirements of board members when they intended it. They did that in 2012. The governor's CV is the definitive statement that it doesn't capture volunteers, and the only mechanism for exemptions deals with paid employees. So, yes, we would like you to rule that it's a contract impairment violation, but there is sufficient, more than sufficient, for Your Honor to rule that the statute simply doesn't apply to volunteer board members. If I may go, while we're still on the statute, I would like to speak a little bit about the statute of limitations. This is not in the brief, but it is, I think it's plain from our papers. The plaintiff makes a very big argument out of the fact that the word any is used to set off the phrase 365-day cure period. And if I'm understanding his argument correctly, he's saying, well, that means I get to string as many 365-day periods together as possible. I could pick any one of those, and my one-year statutory clock begins from that point. We believe that is a faulty reading for two reasons. One is, and it goes back to the 1987 Act. If you go to 1987 Act, Your Honor, and again, this is an Exhibit D to the Carucci certification, the statute in that iteration had two cure periods. The statute was going to had an expiration date, and you also could count 365 days from your date of appointment. So you had 365 days from the effective date of the statute, or 365 days from the date of your appointment to cure your residency. When the statute got amended to its present form, the legislature removed the language regarding the expiration date of the statute. So there is no longer a choice of any cure period. It's not a question of the expiration cure period versus the appointment cure period. There is only now one cure period. So any is really just a leftover word. It's almost dead letter in the statute. This statute very clearly sets out a 2-year statute of limitations. It runs from the date of an appointment. You have 365 days to cure. If you do not cure, then the clock is 1 year from that point. And if you follow that statutory construct, and we believe that is the only reasonable interpretation without turning the statute of limitations into an absurdity. If you look at it that...
Isn't such an absurdity here, though? I mean, when we talked about the Kennedy case that, happened in Newark, where the individual resided in Newark, moved out, back and forth, so if you don't get caught, you're forever absolved from any relief under the statute?
Your Honor, we acknowledge in this case that back and forth in our brief, but that's not this case. The absurdity, in my view, comes from when you are appointed as an out-of-state member and you never cure. And in the case of Mr. Brown, he was out of state on the date of his initial appointment. He got reappointed without a break in service, and he's still out of state. So under plaintiff's interpretation, the statute of limitation would only run if he moved back to New Jersey, which in my view would be absurd. That's when we wouldn't need the statute of limitations. That is also a reason why, and I think Your Honor picked up on this, the legislative intent, going back to whether it applies to volunteers, the governor knew and the Senate knew, because their residencies were on the nominating papers, they knew that Mr. Brown had never cured her residency. They knew that. They knew he had a year, and he served for several years, and then got reappointed and has now been serving for several more. So this is not the case where they may have expected him to cure and thought he might cure. They knew he was an out-of-state resident, and they, on multiple occasions, made serial appointments of folks who had out-of-state residency. So again, I keep coming back to the fact that because this was the governor's CV, His thought on this, his statement, and his actions are embedded in the legislative history. So we think the statute of limitation is clear, and it has to be clear. In order for a statute to have any sense of fairness, it cannot be an indefinite period of open-ended litigation. The way this statute is written, it's more like a statute of repose. It imposes a hard deadline. 1 year cure, 1 year clock running on the statute, you must file. If not, you lose that right. It's not like your typical accrual statute. We would also argue, Your Honor, that under Winbury, there was not a lot of discussion about this morning, but it is in our brief. We believe under Winbury that the rules of court actually trumps the statute in this case and sets a very short time frame, 45 days. It could only be enlarged in the interest of justice. We look at those interest of justice cases, and what we see when I read those cases were a couple of things. One is there were cases where the statute was missed by just a few days or maybe a few weeks or even maybe a few months, but it was not a long delay. And there also was some good faith explanation on why the plaintiff in those cases delayed. Here, there is no real explanation for the delay. The plaintiff knew these were out-of-state residents. He understood what that meant. He commented on that publicly in his news column, and yet he waited, in some cases, years to file suit. So plainly out of time under Winbury, plainly out of time under the statute of limitations. If I may, I just have a few other points on back to the comparament, because I did want to hit every one of those 6 factors. We've already spoken, Your Honor, about contract breach and it being significant. We do not think there is a legitimate purpose as applied to Rutgers because the only stated purpose is one of jobs, government jobs for New Jerseyans. We do think, and I've already touched on this, the conditions placed on Rutgers would be unreasonable, certainly not sufficient to override a contract that we see in the case law at the United States or at the state level.
What about the basic argument that plaintiff makes that the New Jersey First is a statute of general application, and even under U.S. Supreme Court precedent, you don't get a contract clause. Don't even have a contract cause of action.
I read those cases to suggest, Your Honor, you do not have a contract impairment if it is incidental effect on an institution. Our position very strongly is this is not an incidental effect. As I said earlier, you are making ineligible from an out-of-state perspective the entire Board of Governors of Rutgers. And it's not just, as my colleague says, well, you're hampering the governor's appointment ability. The Board of Trustees appoints 7 of the 15 board members. Their hands are tied now, too. And that is very central to the management and governance of this university. So it really is sort of a double hit. You're altering the manner in which the appointing authorities, the governor and the Senate, can appoint these members, and you're cutting off access to a global talent pool, but you're also encumbering the hands of the trustees themselves in their appointment authority, which is very clearly part of the 56 contract and is very clearly part of any change that would need to be made would have to have the consent of Rutgers. And the last factor on the multi-factor contract clause is the NJFA unrelated to an appropriate government objective? We again said yes, because the true objective of this case is to secure jobs for New Jerseyans. That has absolutely nothing to do with unpaid board members. The other point I would just like to make, Your Honor, is that if you look at those cases where the United States Supreme Court or other courts have invaded a contract, has allowed the state to impair, most of those cases, many of them have dealt with emergencies, have dealt with something that is really at the height of public welfare and at the height of police power. That is not the New Jersey First Act. It's not, frankly, it's not even close to making those standards, to satisfying those standards. So we think when you look at the 6 factors, easily this case is an impairment case. If you choose to look at the statute, we feel volunteers were nowhere in the mindset of the legislature. It simply does not apply to volunteers. If you disagree and look to the statute of limitations, then this case is clearly out of time.
Okay, thank you very much. Any rebuttal, Mr. Kaluga?
Briefly, Your Honor.
Yeah.
Not in any particular order, Your Honor. The argument that they haven't been poor stewards, I think we would take exception to that. I also don't think that really matters to the question, to the resolution of the statutory issues of the case. But I just, want there to be on the record that there is certainly a segment of the Rutgers community that views the service of these out-of-staters who are not accountable to the Rutgers community as an example of poor stewardship. The comment was made that in order for Rutgers to reach the next level of this international achievement goals that it has, that it needs to have out-of-state people on its governing board. I don't think that's been proven. I mean, it's easy to say that, but
your position would deny them the talent of these 4 individuals. So, I mean, that's something they want to take advantage of.
Well, but what's the question is, what's the is it necessary? Is it to reach this sort of international objectives, these objectives of worldliness or whatever that they aspire to? Is it essential that they have access to them? Their papers talk about all the exchange students, the exchange faculty, the research. Why do you also need this? Why do you need to turn over to an out-of-state person control over $16 billion in public dollars?
It's not. We've already been through this. I mean, there are 4 people on the board of, 15?
Yes.
So the majority are from New Jersey. So, they say they want the option to they feel that the argument was they need the option to get the most talented people for Rutgers, wherever they're from.
Which could lead to a majority of out-of-state board members.
But it hasn't, so...
It hasn't yet, but it could...
And you certainly... I mean, I don't know in terms of the nomination process, when you talk about whatever alumni group you may be referencing in terms of poor stewardship, is there any process, when if Rutgers is recommending someone to the governor, is that anything that's public that there can be comment on and media comment on, etc.?
Sure. I mean, in certainly through the confirmation process, and I don't doubt that Rutgers approaches the governor and say, we'd like to appoint this person, but I have the right to approach the governor. Mr. Cradaville, we all have the right to say to the governor, this is who we recommend, and to appear at their confirmation hearings and oppose them or support them.
So the poor stewardship argument, could be made at any particular nomination, so that would be aired.
It could, I don't think the question of whether they're good stewards or poor stewards, or these individuals are, is relevant to the statutory issues here. What's relevant here is, whether any member of a board of a higher educational institution or state university with this kind of power is allowed to be an out-of-state resident.
You brought up the poor stewardship.
I did. I wanted to
commenting on it.
Comment to sort of say there is a different view on that. We do agree that there's a contract. What we don't agree with is who the counterparty of the contract is. The legislature said the counterparty to the contract is the Board of Trustees. And we talked about whose consent is required for changes to the Rutgers contract. And you have the resolutions. The answer is the Board of Trustees. They are the ones who have the power to consent or withhold consent for those changes that do require consent. Not Rutgers, not the Board of Governors, the Board of Trustees. And they're not the party before this court. And with regard to all the changes in governance that have constrained the otherwise unfettered ability, if you want to look at the face of the 1956 Act, there isn't evidence of consent on Rutgers' part for any of those statutes. Rutgers is given consent in 1956 and again in 2012. But there have been a myriad of statutes of general applicability that have constrained the board. And I also want to comment briefly about the question of the bi-state agency. If you look at A2, actually, I'm sorry, before I get to that, the issue of whether position was in the 1987?
I think.
Yeah, the 1987 version of the statute. As far as I'm able to tell, position is alluded to in Sections B and Section C of the Act. This has to do with the issue of scientific qualifications for jobs requiring scientific qualifications. B deals with letting out an office that you've been given, sort of subcontracting it. As far as I'm able to tell, I'll be glad to be corrected if that's not the case, position did not appear in the operative parts of the Act that are before the court, which are sub A and sub D. That language was added in 2001 for the first time. So sure, 5214.7 had it, but not 5214.7A and D. The argument was made about the provision about the bi-state agency. I think I've covered this, but I mean, just to be very clear, the subject to law exception is for bi-state agencies that have people from other states. There is not a subject to law that is generally applies to any other obligation the state may have, like the Rutgers contract. So you can't use, Rutgers is not a bi-state agency, so you can't use the subject to law exception that applies to bi-state agencies to exempt Rutgers. The last point I want to make too, I alluded to this briefly, but I just want to underscore it for clarity's sake. There is a difference in the substantial impairment analysis for trustee governors and for public governors. I would agree that trustees are allowed to appoint governors, and what's in the 1956 Act, they're the deciders. And granted, there's no restrictions on them. But the public governors, that restriction is not there. That's the discretion of the governor of the state of New Jersey. And there is no contractual right to have review of that decision of the governors. So it is one thing to say, the trustee governors, okay, you are, the New Jersey First Act impairs what is otherwise our unfettered right to put somebody on the board. The public governors, the argument is, this somehow impairs our unfettered right to ask the governor to put somebody on the board, and which we have no power to enforce. So there is a distinction between those two, and I don't want to see them conflated together. I don't think there's a substantial impairment for either, but it's a somewhat different analysis for the public governors, because Rutgers had no rights, and the Rutgers Board of Trustees had no rights to appoint the public governors. Trustee governors, different story.
What about the contract clause argument in response to your Edgerton cite about the law of general application can only have, has been exempted because it has incidental impact, and this case because it affects the governance of Rutgers, which has been the subject of so much specific legislation, it's not an incidental impact?
Well, as I understood the case, it was saying that laws of general application that do not have as their purpose targeting a particular contract are sort of by definition incidental. That's at least how I read the case. But I don't think there's any question here that New Jersey First Act, with the broad expansion in 2011, did not mean to target Rutgers particularly. It was not directed towards undermining or changing Rutgers alone. It was a wholesale change in offices, positions, and employments throughout the state of New Jersey, including Rutgers. And the legislature can regulate Rutgers in one of two ways: by laws of general application, and they can regulate it by specific laws, by changes to the charter. And they affected Rutgers through the Rutgers boards and the Rutgers employees through the New Jersey First Act by a law of general application.
Okay, thank you very much. The court's going to reserve decision on this case, and since none of the parties had mentioned this SAHLI, S-A-H-L-I case, and I should have asked you to comment on it prior to the argument today, so I apologize for that. But I'll give you a chance if you can do it by next week, and you can do it simultaneously, and if you want to respond, you can also respond. So, if you get me by March 29th, just your comment on whether this has any bearing on the interpretation of the same language in a very different statute, I'd appreciate that. And since I am going to allow a response, let's see, that would be by August 5th. I'll give you 1 week to respond. If you want to comment on what the other side has said, we'll just do this simultaneously. If there's anything that you think would assist me in deciding the case as you reflect on the argument today, going home in the car, you say, wish I would have said X. I'm going to let you say it in that letter and respond to each other, because it is, I think it's an important case for Rutgers. It's an important case for the state of New Jersey. If I were to interpret the act to apply to volunteers, if there may be 100, I don't know how many people would be affected, but it could certainly go much broader than Rutgers Board of Governors, and so I just would invite your continued attention to it. I'm very impressed with the briefs both sides filed and with the argument today, and it's a challenging case. So thank you all very much.
Thank you, Your Honor.
Thank you, Your Honor.